what this class is about is this is about estate planning and the SCA. It's how to deal with the things that you own and what to do with them, and also in case you want to leave anything to the SCA. Let me share my screen here. And we're going to start with a PowerPoint document. Dum, dum, dum. Here we go. Can everybody see that? This is estate planning in the SCA. Sorry if you hear the husky barking in the background. My husband is trying to quiet him down. But you also might hear the Great Dane cheering a little bit. And while we have it, we also have the 12-pound dog that actually runs the house, Speck. Okay, she's a speck of a dog. She's not that big. Yes, she's 12 pounds. She's fat. Yeah. Anyway, what this the formal title of the class is Estate Planning in the SCA, Structuring Your Estate and Retirement Investment Accounts so you can contribute to the SCA now and in the future. It, if stretched, will hit 2 hours. Okay. If you have any questions, just hit the little button to raise your hand, and we'll do it that way. Okay. Now, I am Mike Hobbs, aka Master Llewellyn at Tiernon. If you don't feel comfortable using the term master, please use capo. That's the Italian word for a master cook or the head of a kitchen.
Or just say, hey, Dork, what's up?
Dear, go away. You didn't hear that, did you? Good. I'm glad you didn't, dear. Okay. Now, this is who I am here. Can you all see that page? Okay. I've been in the SCA for more than 35 years, and I've lived in 4 kingdoms. I'm a Laurel and Pelican, and I've been an officer at every level of society from kingdom on down. And I'm currently on a consultative committee working for the board of directors. I'm also one of the 2 people that ran SCA 50, if any of you attended that. Okay. Now, Mike Hobbs has worked in the finance industry for over 25 years. I work with investments and retirement accounts, and I currently work for one of the top 25 small advisory firms in the US. So I know what I'm talking about. Now, let's start out with this, though. I'm not giving you investment advice. This is for information only. Okay? If you want actual investment advice, I suggest you talk to your investment advisor or your accountant or your tax advisor or your spouse, who probably actually balances the checkbook, right? All right. Now, the rules for this are, rules for all of this are, especially number 1, this is the one that's going to come back and bite you. So you need to memorize it. If it is not in writing, it does not exist, period. All right. Now, having been in the business as long as I have, and being a gay man who's married with a weird family, whom I love some of the members of my family, but I have a weird family like many of us do. I've seen things come back and bite people many times. Okay. So if you do not put it in writing, do not expect it to occur, period. Okay. Now, honesty and openness prevents disputes and issues. Okay. Make sure that your spouse and anyone else knows what you intend. I mean, be open about it. The worst thing you can do in these cases is surprise somebody. Because the SCA is supposed to be how people have fun, how people express themselves. Using it to punish your third cousin twice removed because you don't like them is not the way to go about it. So don't surprise anybody. Now, simplicity saves time and it saves a lot of trouble. If you write down something that you want to occur, make the outcome that you want as simple as possible. Explain it as fully as you can and be simple about it. For example, I intend on leaving $100 to the Society for Creative Anachronism so that it gets put into the bank on an aggressive growth policy. And in 100 years, the account should be the size equal enough to buy Cooper's Lake Campground in Pennsylvania. That might get you some issues. But I intend on leaving $100 to the SCA so that at Penzic, somebody can raise a glass to all of those who've passed this year. That's simple. If you understand what I'm saying. Okay. Any questions so far, guys? All right. Now, if anything comes up and you don't know how to handle it, review rule number 1, 2, and 3. Okay. Rule number 1, as I said, will come up again and again and again. Okay. Now, here's your inventory and written instructions. Okay. Number 1 is the most important one of all of these. Do you have a will? If you are over the age of 60 and you do not have a will, you're asking for trouble. Period. And I'll explain later on where some of this comes into play. Okay. Wills express your desire for how things are to be done. They're also a way of expressing your love and affection for people and organizations, as the case may be. Now, have you made an SCA inventory? Anybody out there made an SCA inventory? Hands? Okay. I see that. When you pass, what's going to happen with all this stuff? Simple. What's going to happen to it? So you need to know what you have, first of all. I know I have 2 coronets. That's why I put coronets out here. Oh, my Baron too. Oh, sorry about that. I didn't mention that. I have 2 coronets, but I also have 200 baseball caps. I like baseball caps. You know, it wouldn't quite fit in the SCA inventory, but you get an idea of what I'm saying. You know, how much garb do you have? What is it? How about all that camping gear you got out in your garage, in your shed? What's going to happen to it? Do you want it to go to the Goodwill? Or do you want it to go to somebody that can use it? You know, if you don't know anybody that can use it, then yeah, it goes to the Goodwill. But that's where your being a responsible adult steps in. You put it in writing. Okay. You know, you can leave camping gear to the local group if you want for them to use at events. Now, if you leave it to them, make sure that they can decide how long to keep it or not. Don't put anything that says they have to permanently keep it, because that adds additional expenses and it adds additional paperwork to them. And you have to find somebody who can store it all. Okay. And the reason I specifically put camping gear here is because my tent got destroyed last summer in a thunderstorm. I'm looking for a new one. You know, when you roll out your tent so your husband can keep all of his carpentry gear dry while he's outside working on something, and the storm of the century comes through, yeah, you kind of accidentally ruin your tent. But you can leave stuff to your local group, or you can leave stuff to a particular individual. Just make sure that your wishes are known, because if your wishes aren't known, it's going to go to the Goodwill. Let's just be blunt about that. I have wandered through the local Goodwill, and I've also seen stuff online where people's shields are at the Goodwill. You know, I've seen a suit of armor at the Goodwill. So you need to make your wishes known. Real simple with that. Now, scrolls an artwork of that type, that's interesting as well. I've been in the SCA 35 years. I have an average a scroll a year. I have 35 scrolls, need something done with. What do I want done with them? Well, that's what you need to decide that as well. You can leave some significant stuff to your kingdom or your local group, but let's be honest, it has to be significant. If it's just a scroll that you received 35 years ago in when you were living in another kingdom and they have no idea what it is, it's going to be put in storage and left there. So just be realistic, okay? In my case, my laurel scroll is a wooden box, and I intend on being, when I'm passed, I intend on being cremated in it. And that's part of my wishes. But then I have things like my pelican scroll, that's a stained glass window. Who do I want that to go to? How do I want that handled? Now, if you just choose to leave everything to the SCA as an organization, I'm sorry, it's just going to go in storage for the most part, unless you leave money to the SCA to bring stuff out and display it. I'm just being blunt and honest. Am I making myself fairly clear on that? Okay. So if you want something done or you want something special done with any of this, just make sure you have it in writing and explore your possibilities ahead of time. I know that there are people that have left numerous items to the local group, and the local group is not quite sure what to do with them. I mean, a lot of it goes into gold key, yes, but what are we supposed to do with that spoon that you were given 50 years ago that has your device on it? Let's anticipate what they'll have to go through in storing it, displaying it, etc. And that makes things much easier. Okay. And as I said, do you really want all this to go to the Goodwill? After Penzic, I wandered through the Cranberry Goodwill once. You'd just be amazed what you find at that Goodwill about a month after Penzic. Oh, okay. Now, the number 3 here is very important. Do not rely on your friends to carry out your wishes if they don't know them. You can tell them all you want, but if you don't put it in writing, it doesn't exist. And also, make sure you go through it with them. For example, my friends know what I would like to do with my friends that I intend on helping distribute my SCA stuff. They know exactly what I'd like to do because we've discussed it. You know, anything my husband doesn't want, they will follow my written instructions on how to distribute it. My Henry VIII, I have a complete Henry VIII that Mistress Anne made for me. You know, based on the Holbein painting of he and Anne Boleyn. I know exactly who's getting that if they want it. But that's the sort of thing I mean. That's the easiest way of not getting angst. Okay. Now, any questions, guys? All right. Let's go to the next one here. Avoiding issues. Here we go again. Verbal versus written instruction. I can tell you everything on the planet that I intend on doing, but if it is not written down, it don't mean diddly squat. Again, as I said, if it isn't written down, your wishes are not going to be carried out. Now, beneficiary designation versus will probate instructions. We'll talk about that here. Do you all know what a beneficiary is? A beneficiary is this person that is supposed to receive something from you if you pass. And depending on the type of account or the item being given, it goes through various processes. Okay. In your will, you can tell things that occur. Beneficiary designation is if you have accounts like IRAs and things of that nature, you can tell the group running the IRA or the 401k, et cetera, exactly who's to get it. For example, I have a small IRA that's going to go to the SCA. My husband knows that. That way it avoids probate and wills and a lot of angst and a lot of costs associated with getting that taken care of. So if you can designate a beneficiary on any of your accounts, do it. Just absolutely do it. And if I pass before my husband on that IRA, he gets it. But my contingent beneficiary, my secondary beneficiary, is the SCA, and he knows that. Okay. Now, number 3 is really, really, really important. Okay. Having helped a lot of people through probate, et cetera, and settling out accounts, nothing about anything you do should be a secret. Okay. The worst thing you can do is surprise somebody with a beneficiary by suddenly them finding out if they expected to be your beneficiary that they're not, and that somebody else is, because not only does that create a lot of angst, but also can lead to some legal action. So just be careful of that. Okay. Now, tips to prevent disputes. If you have a spouse, make sure they're taken care of first and they know of your wishes. Okay. That's the easiest way of preventing any kind of dispute. Besides, they're your spouse. You love them. They know what's going on. They know what your wishes are or should. Just make sure they do. And then make sure that they know the special place the SCA has in your heart. Now, my husband, God bless and love him, doesn't play in the SCA, but he knows what it means to me. And that says a lot. Okay. Number 5 is an important one. And a lot of people don't know this sort of thing. Okay. Make sure the marriage laws for your state, you know the marriage laws for your state, as they can screw things up for you. I live in Indiana. Okay. And I'm going to use Indiana spousal law. If you do not have a will, okay, your spouse only gets 50% of your estate automatically. Did you know that? A lot of states have laws like this. So your spouse, if you don't have a will, your spouse will only get 50%. And anybody else that legally feels they have a claim, such as that brother you haven't talked to in 25 years, who, oh, he's finally died, let me see if I can get some money out of him, can now file and get up to 50% of your estate if you do not have a will. Okay. Now, consequently, you can also, if you do have a will and you do have your wishes written out, if you don't want them to receive anything at all, and you don't want them to be able to argue, oh, he forgot, or he wasn't mentally incompetent or something like that, you can list that person and leave them $1. And that will stop any and all legal challenges in the tracks. Okay. And I know specifically about Indiana's law at this point because my husband and I are going through this right now while we're trying to get our wills taken care of. But this is an issue in a lot of states. And also, if you have a civil union that's been converted to a marriage, or you just have just a civil union, you need to know your state's laws as well, and you need to have everything written out in a will, or you're going to have issues. Any questions on this part? Okay. And number 6 is an important one, and we're going to come back to it a little bit more too. Make sure you know and list not only the SCA name for all individuals you're giving instruction or bequest to, but their legal names. Okay. How many of you have friends in the SCA that you have no idea what their legal names are? How many of you have because of Facebook, you now know the legal names for your friends, but you've kind of forgotten their SCA names? Okay, let's be honest here. With 2 years of COVID shutdown, we're all kind of screwed up. Hades, quiet. Hades is the husky. Zeus is the Great Dane. Okay, all right. It's very important that you have their legal names when you're doing instruction of some type. If you list their SCA name, great, but have their legal name as well, period. That will stop all kinds of issues and all kinds of items that might pop up. Okay. Heraldic wills. I got asked this a lot last time around. I didn't even think about talking about this last time. And a lot of people want to know about heraldic wills. Heraldic wills. If you have registered heraldry with the SCA will allow you to leave your heraldry to others on your passing, provided they receive the instructions notarized in writing. And that notarization can be your will if it's one of the addendums in your will as well. But the SCA will allow you to do that. So I can give my heraldry to my godson Jamie if I want to when I pass. Okay, now to do that, you must include the following. You have to have the SCA and legal name of the decedent. You have to have the SCA and legal name of the beneficiary. And you have to have the decedent's death certificate and the instruction in writing. Okay, and the SCA will allow you to do that. Okay. Now, can you just simply release your heraldry to anybody that wants it if you don't have somebody you want to leave it to? Yes, you can. But be aware that someone you may not wish to would now have the right to apply for your heraldry. To release your heraldry requires a notarized letter from the decedent with instructions and must include their SCA legal name and death certificate. Any questions on this one? Can everybody hear me?
Yes, Lou.
Okay, good.
Not a question, just a quick comment regarding heraldic wills. I just wanted to say, conversely, if you don't do anything with your heraldry will be retained by the college in perpetuity, and permission to conflict will not be possible at that point because, well, you're dead.
Exactly. Thank you.
Thank you. That was one of the questions I was going to ask.
I had a conversation with a merchant about that once. Yeah, that is a problem.
Yeah, there's a lot of, pardon me for saying it, there's a lot of decedents out there and a lot of heraldry that is locked up for that reason. And that's why in my own will, I do have a clause that says my heraldry will be released. Of course, my heraldry is two rampant Pegasi endorsed, standing back and back, but I don't think anybody's wanted to conflict with me yet, but yes, that is a very, very common issue now in the SCA is turning out to be.
Well, not on heraldry. We haven't wanted to conflict with you.
Have you had any examples you'd like to bring up?
Not in particular, no. It's just, it has been a topic of discussion more and more lately, though, as our population ages.
Mm-hmm. Oh, yeah. That's one of the reasons I wanted to bring up this. I wanted to hold this class as well, because as our population ages, we are coming up with ways that we can benefit those that are younger than us, and the organization itself too. As long as we have things in writing, or we have ways of taking care of that. Any other questions? Yes, ma'am. Let's see. Yes.
Hi. This is more for Dimitri. If you have a bunch of augmentations and things like that attached to your heraldry, if you were to release your heraldry, those documentations do drop off, right? Those don't go.
Right, because the the augmentation is granted. Well, let me speak from the standpoint of my knowledge and understanding of things, which may not be perfect. Your original heraldry is granted to you. Your augmentations are registered as an alteration of that heraldry, so still to you, but when you release, yes, you'd be releasing everything down to the baseline. The augmentations were granted by a court action, which would not attach them back to that heraldry, because essentially what you're releasing is the design of the heraldry, not the end product itself. It allows someone to arrive at that same endpoint, but it doesn't just release it's not a completed product, essentially, is my understanding of it. It is actually an interesting question, and I may discuss it with some folks more experienced than me to see what their opinions are.
Well, as I said, I have been asked a lot recently this very question. So you may actually want to hold a class on it.
I might actually do that. Thank you.
All right. Well, let's see here. Any other questions while we're on this subject? Please feel free, especially because we have some great heralds online. Okay, let's go on to the next topic then, which is a really fast one. Officer records. Somebody brought this one up. If you have been an officer in the SCA, or you're currently an officer, you need to be able to pass those records on when you pass. So you should be making plans in case something were to happen. Now, make sure that as an officer, you know where you have a record of where all the documents, et cetera, are kept. And that should be something that somebody would have access to if, for example, you had an auto accident or something. You know, they should know where to find something. And make sure that any of the computer passwords, et cetera, are recorded so that they can be accessible to your executor or successor. And inventories of the items you've been given or are holding are a godsend. For example, when I was Kingdom A&F's officer, I had a lot of stuff people gave me in terms of how the various rules were for judging were made up and things of that nature. And it provided an interesting history for people to understand how we got to where we were. Any questions on this one? I think this one's pretty straightforward. I was actually surprised when I got this question, but looking back on it, I can see why. Okay. The SCA, what will the SCA request accept and request, and what will they not? While this is a kind of a fuzzy question in general, there are a couple things. Okay. Conditions. The SCA will receive funds if they do something. Okay. If the SCA agrees that Apple iMacs are period and proclaims it unto the known world, they shall receive this funds. Well, maybe, depending on what the funds are and what they're intended for. Okay. If the SCA proclaims that Richard III was the rightful king of England and Henry VII was a usurper and file suit to have this declared, they shall receive these funds. No, no, the SCA will not do this because let's face it, there'd be a lot of cost involved. And I'm sorry, that $100 you're leaving in your will or that $1,000 you're leaving in your will to the SCA would simply not cover it. And it's not worth their time and effort. So they can refuse it. The SCA can refuse anything you give them. And then it would revert back to your estate. And how it's and your executor would then have to decide what to do with it. Okay. And there are people that have done things like this. They've people that have left money to the SCA with conditions that aren't great. Okay. Like this here. Let's next screen here. Come on, computer. If you leave targeted funds say they have to be used for a particular purpose. Okay. The time and reporting requirements may be extensive and just not worth the SCA's time and energy. The cost may outweigh the benefits. Here's an example. All the funds must be spent in making sure that Swedish dance classes are held each year in the March of Valor. Of Valtalor, that is. Well, first of all, it's Swedish dance. Bad joke. Okay, bad joke. But you get an idea of what I'm saying. If you leave this money, the SCA has to confirm every single year that the money is used for that purpose. And the SCA can choose to refuse it for that reason, because that means that the SCA has a lot of reporting they have to do. And that might not be just not worth it to the SCA. The 5% of your IRA that the SCA gets every year might be, let's say, $500. Well, if the time you spent recording this and making sure it's met, etc., costs the SCA $750 in paperwork, time, and travel, you see what I'm saying. So if you're going to target funds if you're going to leave money to the SCA, be realistic. Just be realistic in what you're trying to do. And be simple. Okay. Liquid assets versus non-liquid assets. And this can be an issue. Liquid assets is simply put money. You're giving them cash. Okay. Liquidable is something that's easily sold. That gold bar I'm leaving to the SCA is intended to be sold. Okay. I'm leaving my 440-acre castle in just within West Virginia to the SCA. Well, the SCA can do what it feels it wants to do with that. Well, okay, the SCA is going to sell it. That makes it liquidable. Is that pretty straightforward?
Mm-hmm.
If you can easily sell it, it's liquidable. Now, non-liquid assets are where we get into issues when you try to leave something to the SCA or SCA group or something of that nature. An example here. Lord George's sword shall be donated to the SCA and kept in remembrance of him. Well, nice. But first of all, who was Lord George? Secondly, why are we keeping his sword? And okay, it's probably going to end up in storage. There you have it. Unless you leave a little bit of money to help it be displayed once in a while. Now, eventually, what's probably going to happen to Lord George's sword is it's probably going to be either sold or donated somewhere. Period. Let's be honest with that. Now, or this land shall be kept by the SCA in perpetuum and used for SCA practices by the Shire of Beltsmoor. Depending on the SCA group or the SCA leadership itself, this may be kept, like it says, or it may be refused. That's why there are things you can specifically do in case you have non-liquid assets you want held for the SCA. And we'll talk about those in a bit. Okay? But that's what we mean when people are talking about liquid versus liquidable assets versus non-liquid assets. Any questions on this? Okay. Let's go over here. Okay, here's your type of investments you might have. That's Widget, by the way, my kitty. Okay, type of investments. You have stocks, and you know what those are. Bonds and CDs. Stocks is where you actually own a portion of the company involved. Bonds or CDs are where you've bought or invested at a bank and have a interest rate that's paid on your cash and a date when it will come back to you. Mutual funds. Mutual funds, I don't know if you know what those are or not. Mutual funds and exchange traded funds are very similar. Mutual funds are where a company buys a lot of shares in different companies, and then you can buy a share in that fund. So you own a tiny piece of each of those shares that the company bought. So a mutual fund is a whole bunch of shares popped in one fund, and you're actually buying the fund. Okay. Exchange traded funds are very similar. They're except in this case, it's instead of a mutual fund itself, you're actually buying a tiny share of the stock itself. Now, do you know what annuities are? Okay. Annuities are something where you buy, say, $100,000 at an insurance company. And in 30 years, they'll guarantee you'll get that $100,000 back. Or over the course of 30 years, you'll get that $100,000 back with some interest. Options. Options give you the right to buy shares of stock in a company at a particular price. A lot of companies give these to their employees. And when the employee retires or when they reach a certain age or when a certain time period expires, they can then buy, say, Google would give you the right to buy their shares as an employee at $100 a share. What's Google trading at right now? About $2,300 a share. So you see where those could be a good thing. You can leave those as part of your estate. All of these you can leave as part of your estate. Or alternative investments. My friend George needed to open a bakery, and so I gave him $500, and in exchange, he gave me a tenth of the ownership of the bakery. Okay, that's what this is. These can also be stocks and companies that aren't publicly traded, things of that nature. Okay, so when you hear alternative investments, they're not publicly traded. Okay, now we're going to talk about the types of accounts involved as well, where we have brokerage accounts versus retirement accounts when we're talking about people retiring. Okay, now a brokerage account is you're simply investing your money and you buy, sell all the time. So this is what most people do. Now, retirement accounts are the ones where you specifically put in money at a certain rate over time until you retire. Okay. So that's what the difference is. If you hear somebody talk about a brokerage account versus a retirement account. And by the way, that Scooby-Doo is part of the stuff that in my will is being left to my godson, Jamie. He specifically asked for my Scooby-Doo collection. Okay. Now, brokerage accounts. Okay. Just a quick talk about what they are. Brokerage accounts, as I said, are ones where you buy and sell stocks, mutual funds, etc. You can move money in and out freely, all of that. They are taxable accounts. So if you make a profit in them, they're taxable. Unlimited inward and outward withdrawals. There's no restraint on that. And the types of investments are basically anything you want to invest in that the company allows you to, that you have your account at to invest in. So you can do mutual funds, you can do stocks, you can do bonds, you can do CDs depending on the company. You can also do things like buy alternative investments if the company allows it. But the companies will have restricted lists as to what alternative investments they may and may not allow. Okay. These brokerage accounts normally do not have beneficiaries. So when you pass, they're part of your estate. Okay. So that's where F comes in. They're probatable. That means if you pass, they're part of your estate. They have to go through the probate process, and there's a lot of paperwork involved. Okay. Your executor decides how to divide it up, etc., unless you specifically state that in your will. There's something to be done with them. This can be easily overcome, however, and that's where number 2 comes in. Designated beneficiary accounts. Almost every firm out there will allow you specifically to designate a beneficiary for a brokerage account. They don't do it when you set up the account. You have to specifically ask them to do it. You have to reach out and tell them you wish to do it. Okay, so what happens is instead of going to probate, this account is not part of your estate and will not be part of the probate process. So if I were to leave my account at a brokerage where I have Scooby-Doo stock, I could make Jamie my godson Jamie my designated beneficiary on that brokerage account, and it would transfer to his name. It wouldn't have to go through the court system, wouldn't have to involve a lawyer, none of that. It's a lot simpler. And if you can do this, do it. I am not joking. You will thank me. From the grave, you'll thank me, but you will thank me. If you can designate beneficiaries on these accounts, you absolutely want to do it. Okay. Now, let's talk about retirement accounts. Oh, wait, does anybody have any questions here? I think this is fair. This one's fairly straightforward. Okay. Trusts. Now, this is where I meant if you want to give the SCA money, etc., this is something you can do. It's a type of brokerage account. And what this does is it's an agreed upon legal arrangement through which funds are held by a trustee and used to benefit a third party. And you can create this before or after you pass. You can create it in your will if you want, or you can create it before your will to make sure there's no glitches. Now, what this does is this states your will, your wishes, okay? But it doesn't, why this is good for the SCA is because you set it up so the SCA gets funds, and the trustees of the trust are the ones that are responsible for making sure that occurs. Okay, instead of saying the SCA has to set up a trust to do this, if you set up a separate trust, and you could do this for anything you want to benefit or anybody you want to benefit. Okay. Being where we're talking about reporting and things like that is these trusts are usually taxable accounts, and you have to get a tax reporting number from the IRS, and that's why it's a lot of paperwork for that the SCA would have to deal with if you tried to get them involved with this. But you can make them the beneficiary of the trust, which means they don't have to worry about any of the paperwork, etc. The trustees worry about that, and that can be your bank. You can make your bank a trustee. Then they would deal with it. Now, they can be irrevocable or revocable. What that means is, obviously, irrevocable means once you put stuff in, it's there, and you can do nothing about it. You would have to go to court and legally break it. Or they can be revocable, which means you can put something in, but you can always take it out and say you've changed your mind. But when you die, it becomes irrevocable. See? If you do create a trust, and there have been people that have created trusts and made the SCA one of the administrators on it, do not expect the SCA to do this. because there are just so many costs and so much paperwork involved that it just may not be worth the SCA's time. That's pretty blunt. So if you do create a trust, you can make your niece or your nephew or your godson or the bank, and the banks do a lot of these, the trustee, to make sure that whatever you're trying to do is being done. Any questions on this? Okay. Let's try this one here. Here's some additional resources too, if you want to talk about trusts. These are some pretty good places to go. Now retirement accounts. I deal with these out of my 8-hour day. I would deal with these 7 hours and 59 minutes of every day. So I'll give you an idea. Okay. The most common types of retirement accounts are traditional IRAs and Roth IRAs and 401s. Okay. Now, these traditional IRAs, by definition, that's pre-tax contribution. So when you this is something that you can contribute to. You can contribute quite a bit actually each year, and once you pass a certain age, you can do more. Now these are, you might hear them called SEPs, you may hear them called rollover IRAs, you may hear them called contributory IRAs, but these are just traditional IRAs, which is independent retirement accounts supposedly. These are ones that you would have with a broker, and this is also, if you hear the word rollover, what that means is somebody had a 401k somewhere, and they either left the company or they retired, and they rolled the account into an IRA. And these can have quite a bit of money in them. I'll just let you know. Now, a Roth IRA, that you can contribute to as after-tax money. Now, the traditional IRA, if you're in a 401, you can't contribute to it. The Roth, you can, because it's post-tax income. Now, as I said, there are limits to the amount you can contribute to these, and they are defined by your age. There's also 401ks, and most of us on here right now probably have a 401k with our company. 401k is where money's taken out of your paycheck every time and put in this account. Just a moment here, I have a stampede going on. Just a second here.
We have to go outside.
They just went before I got on the line.
But they want to go outside again.
That was the Great Dane. And there goes Husky. Go on. Zeus, outside now. Anyway, now 401 are company created accounts, and they have a much higher contribution limit than an IRA does. So I like these. Now, each of these accounts, you can designate a beneficiary on. Okay. Now, your primary beneficiary is your primary beneficiary. That's usually your spouse if you're married. Oh, you love Great Danes and tiny dogs. Well, love them too. Love them too. I just saw the chat that popped up. Your primary should be, well, that's my thinking, your spouse, but that's up to you. Now, the contingent is where you can do things like leaves. If your spouse passes before you, it would go to your children. In my case, if my spouse passes before me, I have my contingent set up as the SCA, and he knows that. And that's why any of these accounts you can do that with. All right. Now, what if they ask you if you want pro rata versus per stirpes? Okay, this is a term that confuses a lot of people. Pro rata means if you have more than one beneficiary, primary beneficiary, or a contingent beneficiary if your primary is passed, that the money goes to whichever beneficiary survives. Period, all of it. Or it's if you have 3 primary beneficiaries and one of them passes, it's divided among the remaining 2. Now, per stirpes means if your beneficiary passes, their share goes to their children. It doesn't get redivided up among the primaries. Their share goes to their children, or whoever their beneficiary is. Yeah. But usually their children. Now, you can have organizations as beneficiaries. A lot of people do, and that's the easiest way of dealing with this sort of thing if you want to leave money to the SCA. You would have to get the SCA's tax number and their address, and that's easy enough to do. There are also other types of retirement accounts. There's CRAs, which are company retirement accounts. There's I-401Ks. There's profit sharing plans, and there's 403Bs. Out. Nope. Go. No. Go. Okay. CRA is a company retirement plan account. That they're not that common. These are usually administered by your company directly, and they're not very common. Okay. An I-401K is if you're an independent contractor or you have your own little company, you can, or you only have a few employees, you can open up your own small 401K plan. That's what an I-401K is. Now, profit sharing is if your company decides that they've made a pretty good profit and they want to share it with their employees, they can do so, but they'll have an independent plan out there that they specifically put the money into. And these are usually taxable accounts, depending on how they're structured. Now, they can be non-taxable, but they're usually taxable, most of the ones I've seen. And they become available to you when you retire. Okay. And then there's 403Bs, which are basically 401Ks except for public employees, usually school teachers, etc. Okay. All of these can have designated beneficiaries the same way you do on the other accounts. Do I have any questions while I'm talking about these?
I have a question.
Yep.
So going to your, when you were talking about designated the beneficiaries with your pro rata and
Per stirpes.
per stirpe. Okay. Can you do both? So let's say I have 2 children and let's say my kids have children, one, heaven forbid, passes.
The companies will usually not allow that.
Okay. So I
Now,
can't.
what
Okay.
they'll usually make you choose one or the other.
Oh. So if I did, like, if I chose my children, that surviving child then could that child then choose to divide
Whatever
it?
they choose to do with it at that point is their responsibility.
Okay.
Okay.
So they can choose to divide it up.
Exactly.
Complicated.
It can be, unless you tell them otherwise. They're going to be pro rata.
Okay.
That's usually the default for everybody.
Right.
Okay.
If like right now, my children are still under 18. Do I still I've been told I still would need somebody who's over 18 to administer.
You would want to have somebody in your will as their guardian. And if they're mentioned in your will as their guardian,
Uh-huh.
then they can set up a plan in the child's name with them as the guardian.
Okay.
That's the easiest thing to do there. Some other questions? I know that pro rata versus per stirpes is one that confuses a lot of people. Any other questions? All right, let's see here. We're gonna go to my final slide, but coming up on noon here. This is a reiteration of a lot of stuff. Okay. Oh, by the way, do you like the picture?
I love that shirt.
Thank you. Thank you. I love that shirt too. Actually, when it wore out, I got another one just like it. So my household got that for me. Okay. Again, if you're wanting to avoid issues, verbal versus written instruction. Absolutely have it in writing, but make sure you reviewed your wishes with your executor or your spouse, so nothing is a surprise. Okay. Beneficiary designation versus will probate instructions. If it's at all possible to put a beneficiary on those accounts, do it. Absolutely do it. It will save angst. It will save money. It will save time. And people will think, oh my God, they're brilliant the way they did this. Okay. Absolutely do beneficiary instructions if you can do that. Now, again, for beneficiary disputes, nothing about what you're doing should be a secret. Nothing. No, great. You want to surprise the local SCA group with $1,000 to hold a party at Penzic. Great. Just make sure your spouse is aware of that so that they're not surprised. You know. Again, tips to prevent disputes. If you have a spouse, make sure they're taken care of first and that they know of your wishes. Okay. And make sure they know the special place the SCA has in your heart. Okay. That is my presentation slides. Now, are there any circumstances anybody's come up against that they'd like to talk about?
So Luz,
Oh,
sorry.
go ahead. Go ahead.
So I have a question in regards to the SCA being labeled as a beneficiary, and you have, so there's SCA Inc. And is there a way to specify down smaller for like the beneficiaries?
Yes. You can state that it can be specifically for the use of a local group, but you have to be as specific as possible. And you would want to talk to the Kingdom Exchequer as to how they think this could best be labeled.
Okay.
Hear that, Kingdom Exchequer? Yes, you can leave something specifically to a local group, but you have to be very specific.
Now, by very specific, can you leave, say, I want to leave X amount of dollars to the Shire of Starencotha to assist in the running of events? Is that actually okay, or is that not specific enough?
Well, you would have to understand that if, say, you left $1,000, that would probably be, it would probably be done in a year. Okay.
Okay.
So it wouldn't be a ongoing thing.
But if I left a trust, if I added them into a trust where they had access to that yearly fund to help them with running events, does that work?
Yes, but don't expect the SCA itself to run that trust.
Right. That makes sense.
because that just leads to a lot of paperwork and a lot of expenses that the SCA might not find useful.
Sure. Okay. Thank you.
Who else has a question?
So Llewellyn, this is Ariana. I have a question for you.
yeah.
Do you have any suggestions as to what to do with scrolls? I mean,
Yes, I've actually seen a lot. I've seen a lot of suggestions come through.
Okay.
First of all, talk to your family and see if they wish them.
Okay.
Okay. Secondly, talk to your kingdom historian and see whether they have a way of storing them and of displaying them, and how they go about displaying the kingdom's history. And if they don't have a way of doing them, that might be a way of leaving a bequest. Now, in addition, there are some people have mentioned that local museums, etc., do on occasion take donations of this type. But I would specifically contact the museum in advance and ask them. Now, one of the other things you can do is I would follow that up with a a speech with the SCA's historian as well, if nobody else has been able to give you a satisfactory answer.
Okay.
Oh, by the way, somebody did pop up and ask me if 457s are similar to 401ks, and yes, they are. Okay, so that I forgot to put a 457 on my list of retirement accounts, and I'll be updating that when I update the slides.
What is a 457?
A 457 is another type of retirement account. So that's whoop. Stop. My computer just went weird here. Just a second here. It's another type of retirement account, and so it's dependent on the type of organization you're working for. Different types of organizations do have different types of retirement accounts, so that's where that might come in. What other questions do we have here? Oh, and by the way, one of the things you can do is you can also sponsor an online SCA sale of your camping gear or something of that nature that could benefit the SCA itself. That's what I've seen people do. As I said, I have to get a new tent myself soon, so I'll be looking. What other questions might people have here? Yeah. Thank you, John Doe. Clarification, I may not have been clear enough. A 457s are for state and local employees.
I'm going to turn this on.
Any other questions, guys?
Not a question, but just a comment, because I'm at the tail end of administering the estate of two Scadians who passed away. They didn't have a will. Get yourself a will, please, 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 please. And also make sure that you have lists, separate lists if you need to, of all of the different accounts and assets that you have, because in the process of administering, I found pension accounts and IRAs that had never been claimed by the surviving spouse, and
Wow.
we're just left out in the ether. Just
Absolutely great comment here. Keep going on. I apologize. We keep going.
no, it's quite all right. We had to figure out what to do with their scrolls. We had to figure out what to do with everything that they had in their house, and the sale of things probably was only a fraction of what the value of them would have been to other Scadians, rather than selling them to a company that would just wholesale them, or selling them, giving them away to Goodwill. Just make sure that you have everything documented. Make sure people have access to it. So, when we went in, we had no passwords for online accounts. We had no idea of the bank accounts or the IRAs that were in process. So just plan ahead as much as possible. It's really awkward. It's hard to think about this because you don't want to think about you dying. You want to, you have all of the stuff that you love, but you don't know if anyone else would love it the way that you do. So just it's a hard thing to think about because no one wants to really ponder their mortality. But at the same time, you want to be responsible not only to the people who are going to be beneficiaries of what you have in your estate, but also for the people who need to take care of it. And it will give you some peace of mind. It will.
My husband and I are working on updating our wills, since the last time we did it was when my oldest daughter was a baby. And our current wills don't say anything about our youngest daughter. So I contacted a lawyer, and their office sent me a package of paperwork to fill out, and it is extensive and asking questions that there are places I don't know the answers to off the top of my head. So yeah, it's pretty wild, but I'm really glad that they're asking me all these questions, because it's, making me think about, where is all this information? What do I have to do with it? What do I want to do with it? Things
I
like
had
that.
an uncle who died 5 years ago, and he was a hermit. Okay. And my uncle, who's administrating his estate, is still finding annuities and accounts 5 years later. That'll give you an idea. So saying that you need to have things in writing and you need to have things organized where people can find them cannot be overstated. Just cannot be overstated.
Yeah,
Yes,
Anya
ma'am.
here. I find myself in the situation where I am the SCA executor for Gunnar Sigurdsson. And I'm still waiting to sit down with his wife. She's been so busy dealing with the bigger picture items of dealing with his decease that but yeah, I'm glad to actually be paying attention to this, because there's things that I know could have been done better in that situation, and I don't want my guy to have to deal with that. So thank you very much for that. Luckily for me, it's mostly SCA stuff, heraldry, et cetera, et cetera. But yeah, you don't think about how much you have involved in your hobby until you start having to clean up after someone else.
Absolutely. Absolutely. In my case, my husband, as I said, doesn't do SCA, but he loves to do home renovations. And so he helped me clean out my dad's garage when my dad passed. And we have 1,000 screwdrivers. And I'm not joking. 1,000 screwdrivers. So that'll give you an idea. So if I know how to clean up from him, and I'm making sure he knows how to clean up from me.
Yeah. My guy's a carpenter by trade. So there's a van full of tools, and the garage is full of tools. And yeah, we need to sit down and figure out how this is going to happen. We have not written our will yet. We've been officially married for a couple of years now, or almost 2 years. So yeah,
Oh,
we need
wow.
to get that done. Thank you very
Anybody
much.
else have any questions? Well, if I can unofficially help in any way for SCA related items, I'll be glad to. So just reach out to me.
I do actually have a question.
Sure.
If we're going to go to an attorney who specializes in wills,
Uh-huh.
for 1 years ago, and I may go.
Excellent idea.
What should we have prepared ahead of
need-
time to give to him when we go through this process?
Okay. When you go through the process, you need to have an inventory. That's the biggest thing. Okay.
Okay.
An inventory of all of your accounts, including retirement and investment accounts, annuities, CDs, the whole 9 yards. Okay. Now that inventory should also include home, if you own your home, cars, things of that nature. And also, let's be honest, an SCA inventory, or at least a brief listing with brief categories. And as to what your wishes, and make sure that you you go to him with a clear idea of what your wishes are going to be. So I would discuss your wishes between you before you go to see him.
Okay.
Just be ready when you go, and it'll make his life easier and your own.
Okay. Thanks. That helps.
Anybody else?
Actually, I do. That would
Okay. All
give
right.
me a good, kind of gave me a good thought. I don't know who it just mentioned, the attorney gave her a big packet. What do you think about, you see these like you can download for free online packets. Are those a good at least starting point to get used?
They're a good starting point, but just remember that you're paying for exactly what you get.
Right.
Okay. No, but they are a very good starting point. They give you an idea.
That's kind of
You
what
know,
I was
they-
thinking.
Just make sure you create your own inventories.
Right.
Make sure you have your list of accounts and passwords somewhere, by the way. Passwords are very important, because if it's not your spouse and they can't prove, they may not be able to get in access to your account if you want them to. Okay. And by the way, LastPass is a wonderful thing for storing passwords too, by the way.
This makes me feel a little bit guilty for making fun of my mom for writing all her passwords down in a notebook.
There are many times you don't do that for your own
Right.
security. And then there are 1 or 2 times when you do it because it's probably a good idea.
Right.
Well, for her brain, she has to, but now I feel a little guilty about, because now at least I know where the book is. And I think my brother knows where it is, but
Uh-huh.
at least if something happens to her, we know how to get to everything.
Understood.
Yeah. Yeah.
Understood. Well, I think my uncle, who's administering my other uncle's estate, would have liked to have had that.
Well, like I know the safe combinations are in there and that, so kind of important.
Exactly.
Yeah.
Yeah, a short comment on the password thing. This has been a number of years ago when my father-in-law passed. He had an AOL account and did not leave the password to anybody. And AOL was still charging 2 years later on his credit card that we kept open for estate purposes. And we had to close that account at AOL to stop charging us. They would not close the account even though we sent a death certificate. It was a mess.
That makes
Oh
sense.
goodness.
So
I understand. Believe me, I understand right now. Is
one
there- are
one
there any
other
other?
thing.
Go ahead.
One other thing, is your slides going to be available? 'Cause that
Yes.
was
Yeah.
helpful.
Yes.
Well, thank you.
I'm going to have them available. And as I said, although this is for information purposes only, because I can't officially give you advice, because that's what I do for a living, so I can't officially give it to you. If there's anything unofficially SCA wise I can help with, please let me know. Well, thank you all, and I wish you all have a good day.